Start, is it? Good morning, everyone, and welcome to this morning's Planning Regulatory Committee meeting. I'm very pleased to see you all today, and especially Richard Greaves is the new head of planning here, who hasn't been to one of these meetings before, so we'll break him in gently, as they say. If I may quickly go over some general housekeeping before we start the meeting. This meeting is being held in person at County Hall and is also being streamed live on the County Council's YouTube channel. The recording will be available to view afterwards. A fire alarm test is not expected during the meeting. If the alarm sounds, we must evacuate County Hall. In the event of an emergency, please make your way to the nearest exit and meet at the muster point located at the main car park. Microphones. When you're using your microphone, please make sure it's switched on and speak towards it. This will tell the cameras to focus on you and ensure you can be heard on the live stream. When you're finished speaking, please push the button to turn off your microphone, as this will allow the system to pick up the next speaker. So next is apologies and substitutions. Holly?
We have received apologies today from Councillor Stephen Askew, and Councillor John Ward is substituting, from Councillor Graham Carpenter, Councillor Rob Colwell, with Councillor Brian Watkins substituting, from Councillor Paul Neal and Councillor Alexandra Kemp. Yes,
thank you, Holly. Yes. So we'll next turn to item 2, minutes. The minutes of the meeting have been circulated to, just pointing out to you that on the Appendix B, item 6, it does talk about the conditions that were debated during the last meeting, and it's just here that we said that they will be published, and they are indeed so here. Any points of accuracy anybody wants to raise? You all agree that they're a true, accurate representation of the meeting? Thank you. I'll just sign the minutes off. Thank you. Declaration of interest. Any declarations of interest? There's no urgent business, so we go into the first substantial item.
Chair.
Oh, beg your pardon. I'm sorry, Mike. Sorry,
It's not a declaration of interest, but I'm sort of double booked this morning, so I may have to leave planning a little bit earlier than I might miss the second item sort of thing.
I suspect that this will not go on for a long time.
Yeah, I was hoping.
But if you do, Mike, then thank you very much, and we'll
no worries. I always enjoy planning, by the way.
Oh, absolutely, yes, yes. So we go into the first substantial item, which is item number 5, appeal decision relating to retention of a replacement rail and siding at land at Brandon Rail Sidings, Munford Road, Wheaton, Suffolk. Andrew is going to introduce this report to you.
Thank you, Chair. The purpose of this report is to advise the committee of the recent planning appeal decision in relation to the appeal by Network Rail against the Council's decision to refuse plan and permission reference discharge 2024-0015, insofar as it relates to discharge of condition number 2 relating to a lorry management plan of plan and permission reference FUL 2022-0051. As some members will recall, planning application reference FUL 2022-0051 for retention of a replacement second rail siding at Brandon Rail Sidings, Wheaton, was referred to the meeting of the Planning Regulatory Committee held on the 23rd of April last year for determination. As reported, the siding site was being operated as an aggregate storage and distribution centre with the importation of aggregates by rail and export by road. Whilst the planning officer's report did not include a recommendation for imposition of a planning condition in relation to a lorry management plan, following questions about the officer report presentation, including the impact of heavy lorries on local roads and further questions about points raised by speakers, the committee proposed and agreed that an HGV haulage route traffic management plan was put in place through a suitable condition to direct traffic along the A134. Movement of traffic via the A134 would avoid movement through Brandon Town Centre, which is located to the south of the site and accessible via the A1065. The final condition of the committee was to authorise the grant of permission subject to conditions, including a condition requiring the operator to develop an HGV route management plan. And planning permission was issued in April last year, subject to a number of conditions, including condition number 2, which relates to a lorry management plan. In May last year, the applicant submitted an application for discharge of condition for the lorry management plan. The application was supported by a lorry management plan which outlines the proposed routing arrangements for HGVs accessing and exiting the site, including accompanying signage to be displayed. The proposed wording of the accompanying sign requires that all HGV drivers, if possible, please avoid Brandon Town Centre. The applicant considered that there would be instances when it would be reasonable for HGVs associated with the development to not travel via the A134, but instead to route south along the A1065 through Brandon, for example, to service customers to the south of Brandon, including RAF Lakenheath and RAF Mildenhall. In September last year, the County Planning Authority issued its decision letter in relation to the discharge application. The applicant was advised that it is considered that the proposed wording of the sign is not sufficiently precise and would result in the lorry management plan being unenforceable. The condition relating to the lorry management plan was therefore not discharged. In February this year, the applicant lodged an appeal against the Council's refusal to discharge the proposed lorry management plan. On 20th of August, the planning inspector determined that the appeal be allowed and details submitted pursuant to condition number 2 are approved in accordance with application reference discharge 2024-0015. In considering the appeal, the inspector considered that the main issue is whether the details submitted are sufficient to discharge the condition, having regard to the protection of local residents' living conditions. The inspector agreed with the council that the wording of the proposed signage is somewhat ambiguous and would not explicitly prohibit HGVs from being driven through Brandon Town Centre. The inspector commented that, notwithstanding the material throughput and hence the number of HGVs associated with the regional provision is the same as the site's capacity when only one siding was in place. The additional siding was only installed to improve the operation of the site and increase efficiency and not increase capacity. The inspector considered that permission reference FUL 2022-0051 has secured limitations to the operations of the site through the imposition of further conditions. The inspector considered that these conditions can be monitored and enforced, unlike the unrestricted usage associated with a single siding alone. The inspector considered that as such, despite the ambiguity of the lorry routing signage, the effect of the site's operation on local residents' living conditions would be no worse than previously when only one siding was in operation. In allowing the appeal, the inspector concluded that the details submitted are sufficient to discharge condition 2, having regard to the protection of local residents' living conditions. I'm just going to go back to this one. By way of update, from review of agendas of recent meetings of Brandon Town Council, it is noted that the Town Council has given consideration as to whether to apply for a traffic regulation order, TRO, to ban HGV traffic from parts of Brandon. And as regards the recommendation is that the contents of this report are noted. Thank you.
Thank you, Andrew. You've heard the update report, if you like. Does anybody, Brian?
Yeah, Chairman, obviously I remember the case in question. I think it was still when I was chairing the committee. In fact, I think the first time we were due to meet to consider this application, the meeting wasn't quorate, so the actual meeting when it was determined was the following meeting. Now, I seem to recall that the condition, and this is only from memory, the condition, there was obviously a committee vote on whether or not to accept the condition, and I thought it was to be agreed by the chair and vice chair, you know, in terms of operation, and I can't ever recall it coming back to me as chair, but then that's probably the time after that when the chairmanship changed, and I just wanted to check the chronology of what had happened and when, because, you know, hearing the outcome of that and looking at what the wording was for the sign, I'm hardly surprised that we didn't succeed when challenged at appeal, because, you know, we're always told when we're dealing with planning conditions, you know, that they have to be, you know, defined so as to be relevant and enforceable, and, you know, avoid if possible. It's not possible I'm going that way, you know, there's absolutely no chance of that having any strength to it. And I just wondered how we got to where we was. And I might be totally remiss. It could have well have been somebody emailed me and says, is this wording okay? And I emailed back and said, yeah, it was. But I just cannot recall that happening.
Andrew, do you have any clarity there for us?
In terms of the wording of the actual condition, I mean, pursuant to the recommendation, as I recall, I mean, I have checked our records. The wording of the condition that was imposed in relation to the Lorry Management Plan, that was agreed by both yourself as chairman and I believe Councillor Carpenter as vice chairman. But as regards the actual application for the discharge, no, you weren't consulted. I mean, we consulted the Highway Authority and we also got representation from the County Councillor for Brandon.
Okay. John.
Yes, can I just ask a question as a new person? Why is this being determined here when Brandon is in Suffolk, please?
Over to you, Andrew, again. Postcode, I think.
It's a good question. I mean, it's referred to as Brandon Rail Sidings, but actually sits within Weeting with Brumhill Parish, which is on the Norfolk side of the boundary. But yes, it is very close to Suffolk.
Thank you. Yes. Okay, John. David.
Just to clarify, I go through there all the time. The county sign is literally, I think, right next to, opposite side of the road to the entrance to this yard. I would actually just be interested, a slightly obscure question, but is the station building itself on the Suffolk side, even though it's on the same site?
I believe the actual station building itself is also in Norfolk as well.
It is.
Rather than Suffolk,
right.
yes.
So that site is effectively in Norfolk?
Yes, yeah. It's because of the way the county boundary, there's sort of a protrusion by Suffolk towards Norfolk. But
the county side, which I appreciate is not necessarily the border, sits literally just one side of the railway line.
Yes, yeah. I think you cross over the railway line towards Brandon and you're then technically in Suffolk.
Yes. No, sorry, but forgive me if you will, Chairman. I had a separate question regarding Brandon Station. Is it possible, Andrew, we could speak about that afterwards, if this is inside the Norfolk? Thank you.
Okay. Are there any more questions on this item? I think it's just to do with deliverability of conditions and things like that, that where there was some variance at. So we've been asked to note the contents of the report, which I can say are duly noted. Thank you very much. So going on to swiftly on to item 6, which is Landoff Holt Road, Sheringham, to consideration of the judicial review decision of Hilltop Experiences Limited versus Norfolk County Council. Ralph, I believe you're talking to this morning.
Yeah, good morning. Yeah, I'm standing in for Michael Jaya, who is the case officer. But I also actually presented this item on the day of the committee last time. But yeah, so this is the second item updating members on a planning decision made in committee, and that was in May last year. Members who on the committee will recall that they resolved to grant planning permission for the development of a replacement recycling centre on land off Holt Road, Sheringham, which included the creation of a new access onto the A148 Holt Road, and that was in accordance with our recommendation in the officer's report. Shortly after the permission was issued to the applicant, who were the County Council's Waste Disposal Authority, officers were made aware that an application had been made by a third party to judicially review and ultimately quash the planning consent that had been issued. Just before I take you briefly through the grounds of the judicial review, I just want to remind you of the site and its environs, as this sets the context of a number of the grounds of challenge that were made. So the proposed site, as outlined in red, is immediately to the northeast of the current site, which is outlined in blue, on the northern side of the old Holt Road, which goes along here, on a greenfield site which is currently scrub and grassland. Both the current and proposed site are within the Norfolk Coast National Landscape designation, which was previously known as the Area of Outstanding Natural Beauty. The basis for the current recycling being located within the National Landscape was because of the proximity to the historic landfill site, which is some 250 metres here to the north of where the Hilltop outdoor centre is located. And the key here is it's the owners of the outdoor centre, Martin Reed, who sought to challenge the planning permission. And just for context, this delineates the boundary of the national landscape. So this is all what was previously the AONB. The proposal for the recycling centre was a typical layout comprising a one-way system for the public to access the receptacles they require to dispose of their waste, and a single-storey reuse shop located in the northwest corner of the site. And this is the site looking northwards across the site. This showed the limitation, and beyond this sort of hedgeline and bund is the outdoor centre, where the football pitch is, which is the boundary of who the claimant was in this judicial review. Initially, the review was lodged with 6 grounds, but by the time of the hearing at the Royal Courts of Justice in London, which we attended in February and March this year, ground 4 had been withdrawn by the claimant. So just to briefly take you through, ground 1 was that the County Planning Authority had failed to consider alternatives to the proposed site, including the site known as Stonehill Way, which was in Cromer. This was on the basis that the application site is in the national landscape. However, the Stonehill Way site was also in the national landscape, as was debated in that committee meeting. However, the judgment was clear that our consideration of alternatives was legally adequate given the information provided by the applicant. Our report to members was found to be clear that the site selection assessment provided by the applicant was lacking, and that the officer could not be certain alternatives did not exist outside the national landscape. The court considered our approach taken to be rational and dismissed this ground. And this ground in particular seemed to gain the most discussion by the judge, and the issue of the degree that alternatives should be assessed has been grappled with by practitioners for a long time, so it's quite a long-standing issue, that. However, the judgment was clear that applications fall on a spectrum, and an application such as this does not need the same level of investigation into alternatives as, for example, a new nuclear power station would. The claimant's second ground was that we had erred in our determination that the proposal was not major development for the purposes of paragraph 183 of the NPPF, which is now 190, and that we relied on irrelevant considerations. This is important as there is a higher test for major developments located in the national landscape. However, the judgment was clear that our decision was not irrational, and that on reading of the officer's report as a whole, it demonstrated we considered relevant reasons such as setting, size, and the low throughput of the proposed recycling centre. Their third ground, which related to the second, was that we had failed to, in our report, to advise members whether there were exceptional circumstances for locating the facility in the national landscape, and did not properly assess how the need for the replacement site might be met in another way. The claimant believed the test was necessary, as they believed the site was major development in the national landscape. Obviously, we disputed that. However, the judgment was clear that no assessment was required as to whether there were exceptional circumstances, because we lawfully concluded that the proposed development was not major development. As set out on the slide, ground 4 was withdrawn before the hearing, and this had related to our duty to determine the application in accordance with the development plan unless materials indicated otherwise, so we didn't need to fight that one on the day in court. Ground 5 related to our duties under the Equality Act 2010. That's also known as the Public Sector Equality Duty. The essence was that our report did not have due regard to the particular makeup of children using the adjacent outdoor education, that's the one owned by Mr. Reed, and their particular sensitivities, and had an equalities impact assessment been done, members' decision may have been different. However, the judge's decision was that the level of consideration to meet the duty of section 149 of the Act in this particular case is relatively low. This is due to the low degree of likely impact on children with protected characteristics, and the information that was given to us during determination of the application regarding the vulnerable children themselves. And the judgment put significant weight on the findings of the applicant's detailed noise assessment, which was clear that the noise impacts from the development would not be any greater than what is currently the case from the existing house waste recycling centre across the road. And also that only part of the outdoor centre that could be impacted on was the outdoor playing field, which is already situated close to the main road and the existing recycling centre. So the judgment on this ground found that the council had met its duty and obligations under Section 149 of the Equalities Act. And finally, the claimant sought to challenge the screening opinion carried out pursuant to Regulation 6 of the Town and Country Planning Environmental Impact Assessment Regulations 2017, and they thought we were wrong in law because it had failed to consider certain types of waste and the impact on human health, and there was reference made there to hazardous waste. However, again, the judgment is clear that this is a matter of planning judgment itself, and that we officers came to a wholly lawful conclusion that there was no likely significant effect from the proposed development that would require further investigation through an environmental statement. As stated in the report, the outcome of the judicial review, which was handed down in June, was that all 5 remaining grounds be dismissed by the court, with an order of the award of capped costs to be paid to us by the claimant. We are aware, however, that the claimant has since lodged an application to appeal the judge's decision, and although we don't know the outcome of whether that's going to be given leave to be heard, we will obviously advise members of the outcome of the appeal if leave is given for it to be heard. But in that event, it's worth noting we would only be an interested party, and it would be for the court and the judge to defend their decision on this. So we'd just be an interested party at that stage. We wouldn't need to defend anything further. So thank you. I'm happy to take any questions on the judicial review or next steps.
Thank you, Ralph. Yes, and thank you for the additional update that was applicable. Any questions, members? No. There you go, Ralph. Thank you very much for that. And the recommendation is that the decision of the court is noted. So we're all okay with that? Great. Thank you very much. So that's it. Thank you very much for coming today. I sense that the next meeting we're going to have will be a little bit more challenging in the sense of our decision making in that particular one, which is might be West Winch House in Access Road or something like that. But that's only a potential. Only potential. So the next meeting is on the Friday, the 21st of November at 10 a.m. And can I just thank you all for coming here today? It was an important process because some of us, as I say, to introduce Richard to the to you all. And to see how things are operating, and there's been no change. So thank you once again. Thank you.
Thank you, Chair. I wasn't expecting it to be over quite so quickly.
Well, I did nod to you on that. Anything else you think?
Can I just jump in? I think the recording's finished.